Welcome everyone to another Legal Tech Talks. My name is Frances Anderson. I'm the MD of NetLaw Media. Today, I am delighted to introduce another thought-provoking session with a really interesting panel from the legal and commercial world who will offer their insights from both the firm and client perspective on the law firm compliance Conundrum in conjunction with Adherent. Now, this will be chaired by former law firm CEO Ian Jeffrey. So firstly, welcome everybody. And what I'm going to do is give you a little bit of an insight on the session, but also a bit of housekeeping before I introduce our chair. So this session is going to look at how billing compliance tools are no longer a luxury. As we know, lawyers' time cards are subject to more scrutiny than ever before, and rejections, reductions, and write-offs are all causing a huge loss to law firms. Client billing guidelines and SLAs have become increasingly complex, with no two clients' guidelines being the same. Now, before we commence, let me introduce Ian. So Ian Jeffrey has practiced for many years as a specialist intellectual property and technology lawyer before moving into business leadership. He served for 5 successive terms as a managing partner and later chief executive of Lewis Silkin, a leading specialist law firm. Achievements in the managing partner role at Lewis Silkin, leading the growth of the business by over 150%, overseeing international expansion, setting and driving strategic change, and contributing to the firm's national recognition as one of the Sunday Times best 100 companies to work for, 9 times in succession. Now, before I hand over, as I said, with today, I hope you've all received a special gift. And as we're live, I encourage all of you to join in. Now, that can be through the Q&A function on the bottom of your screen. You can come in live if you like as well. So do click on your name, raise your hand, and then we can actually bring you in and you can ask the question directly. So don't be shy on that. Alternatively, you have the chat function as well. So please, if you disagree or you agree with the panel or Ian, do put your comments in and we'll be tracking them and bringing them in as and when throughout the session. Now, without further ado, Ian, I'm going to pass it over to you.
Well, thank you very much indeed, Francis. Hello, everyone. It's great to be here and have a chance to talk about this very timely topic, the compliance conundrum. As Francis said, I spent quite a few years as a full-time practicing lawyer before moving into the business management, of course, increasingly the technology world, but the lawyer in me is still a little bit hardwired. So I guess one thing that I'm bound to do as we start the session is make sure that we've got our terms defined correctly. I know we've got a very global audience this afternoon, so we'll make reference during the session to a couple of different terms of art. Each of you will be very familiar with at least one of them, but they can be used a little bit interchangeably in this context. So we're going to be talking about, of course, outside counsel guidelines, which will, I'm sure, get called OCGs at some point in the show. And of course, the same construct can be more familiar to people as a service level agreement or part of a service level agreement between a law firm and its corporate clients. So we'll come across both of those, but fundamentally, it's a discussion about the path of a unit of recorded time being put on the system by a timekeeper, and the journey that unit of time, together with all its brothers and sisters, takes through the cycle to end up ultimately being invoiced to the client, examined by their systems, accepted, rejected, challenged, whatever, and one hopes eventually paid. But that's effectively the territory that we're looking to cover, and a couple of the key terms of art we've got in that. The panel's had a good opportunity to chat about the subject before the session. I found those preliminary discussions very stimulating, and I think rather than me give a sort of textual introduction to each of my colleagues on the panel, I'm going to ask each of them in turn to just give a very brief introduction of themselves and just say effectively who they are, what they do within their organizations, and why this topic of billing compliance as part of a broader set of responsibilities is something that's of key interest to them. So can I call first on Anne-Marie to do that?
Yes, thanks, Ian. So I'm Anne-Marie Farthing, the Billing and Collections Director at Holland & Knight. I have been with the firm for about a year and a half, but in the legal industry for 20 years, plus just over 20 years, focusing on client services. My role at the firm is all of the revenue management teams roll up to me, so billing, collection, and compliance areas are a big focus. Prior to Holland & Knight, I was with the AmLaw 200 firm that was comprised of a large insurance defense practice. So I'm familiar with the challenges presented, low rates, slim profit margins, and outside counsel guidelines, all working against the firm, resulting in situations where we're forced to be creative and innovative in order to recover lost revenue. So probably like most of you, that's why I'm here. I have some experience with this, and I know this issue is not going away. And it's not uncommon to see this drop in realization. So I'm hopeful that I can share some insight into my experiences and techniques and that I've seen employed, and hopefully hear what others are doing as well and learn something from you all.
Thanks, Anne-Marie. And let me now pass to Paul. And then Paul, you can pass on to Chad if you would.
No problem. Thank you, Ian. So my name's Paul Fisher. I'm at Pincer Masons. I'm the head of strategy and architecture. This is becoming an interesting topic. I think it's a developing area, and I think we need to get ahead of it. If this develops in the UK, I think we're going to see a significant investment on the firm's behalf in trying to challenge and successfully challenge and force us to rethink the way that we're billing. So we're trying to get ahead of that inside Pincer Masons. I work with Chad Schuessler, who's head of data. Chad?
Thanks, Paul. Yeah, as Paul said, Chad Schuessler, I'm the head of data management at Pinsons. And my team's really responsible of the leadership and oversight of data management and the principles surrounding that. And my interest in this is, as Paul mentioned, this is becoming an increasing interesting area. And I'm particularly interested in the technology enablement we can do to wrap some compliance and assist the firm around this.
Excellent. Can I draw in Angela and then Christine, please?
Thank you. My name is Angela Huffman. I am a senior consultant with Adirant. I've been with Adirant for about 2 years. Prior to that, I worked for a large law firm as an e-billing specialist, dealing with a lot of insurance litigation and outside counsel guidelines and the struggle to get our timekeepers to understand what's billable, non-billable, what requires prior approval. And since coming to be part of OCG and Bill Blast, it's quite near and dear to my heart to help law firms overcome those challenges.
Thank you, Christine.
My name is Christine Smith. I am a senior consultant here with the Adirant Bill Blast team. I've been in legal a little bit over 25 years, always in almost all the time in billing and collection. So this is a topic that's very dear to my heart. I enjoy helping firms with best practices and like Anne-Marie was mentioning, a little helping out with that realization rate that we struggle so much because of those OCGs. So looking forward to our conversation today and seeing how we can all help and learn from one another.
Fantastic. And so thanks very much to all my colleagues on the panel for those introductions, as well as the distinguished set of thinkers we have there. We've also, of course, got a very diverse and experienced group of people on the call as delegates, and we want to make this as interactive and engaging for people as possible. So 2 quick points on that. One is, of course, the chat function is running and we're very open to just observations that people have as we go through, but also to questions that you want to pose. I'll try to pick up some of those questions as we run through the discussion, drawing in the panelists, and we'll perhaps do a sweep up towards the end of themes that have come through. So do use that chat function. The other way we think we can get a little bit of extra interactivity is doing a couple of snap polls during the course of the session. And I think now's as good a time as any to get one of those going and to just draw in some preliminary thoughts from people on this topic, which will help, I think, guide and shape the discussion as we go through. So you should see the first of the poll questions appear there. And we're going to give people just 30, 60 seconds to read those through, start putting your answers in. We will then keep the conversation going, but keep the poll alive just for a little bit of time. From the introductions, I guess we realize that all of our panelists have a significant angle on this conundrum, but probably one of the panelists who's sort of front and center and seeing this kind of issue in practice most days is Anne-Marie. So I wanted to come to you first, Anne-Marie, and just ask, in your work at Holland and Knight, what requirements are you seeing Corporate Counsel making of firms about time capture, about the presentation of bills, and all of the parameters associated with OCGs?
From a time entry and billing perspective, they are looking for us to be very concise. They're looking for us to tell the story, and it's the story that, it's not just the story, but the story that the bill reviewer wants to hear. I often refer to this as it's a game between the firm and the client and the reviewers. We're trying to read what the reviewer wants to see. There are some very definitive terms as far as block billing issues. Words, clerical words you cannot use, but those are very standardized items. It's the subjective things that really are what we're trying to combat, because there's a lot of flexibility in how the guidelines are interpreted. And then from a billing perspective, we are up against a lot of the challenges where guidelines come into the firm. We know that they're not, I think a lot of firms struggle with the fact that you're trying to get these guidelines dispersed, captured in the first place, dispersed, get them out to attorneys in a way that they can understand them and follow them. They're often large and large documents. So just trying to help them so that they're entering time in the way that that particular client is looking to read the story.
Okay, so there's a few things coming out of that, aren't there? There's the need to have a sort of systemic process to capture the guidelines you're being given, and of course you may be given a different set for every one of your major clients to promote understanding of the timekeepers, and then to manage the entire kind of journey of a unit of time through the process. I'd come back to you just quickly on one thing, which was you talked about the need to respond to the question of subjectivity. So not just those trigger words, but the subjective problems that could be. What's an example of that kind of subjective problem?
So often we will see where the guidelines will say that we cannot provide a vague time description. So, vague is very subjective, and one client, these are the things that we cannot necessarily capture with technology. And I think as we discuss this more, we'll talk about the tools and how technology can help us, but there is a component that still is very, very tied to a human resource or a team, trying to help unravel what the client is looking for. Vague descriptions, there's oftentimes they're looking for the who, what, the why, but that doesn't always solidify getting a time card approved at 100% realization. And I think what we see is that not only do we have challenges with meeting this with individual clients, but even with the individual reviewers on the client side, they may have, it's no different than a judge, that their version and interpretation of the time card may not be the same as the next reviewer. So, it really is this, there are a lot of complexities and a lot of components that are challenging to be able to consider yourself compliant with the guidelines.
And before we let you go, just temporarily, Anne-Marie, let's just have a quick look at those poll results. See what your reaction is to the top answer in each case. So I don't know if everyone can see on the screen the top result, the results, but what I'm seeing is that the top challenge people have identified is that guidelines are getting too complex. The issue of whether firms have enough staff resources to be able to handle all of these challenges, the main answer is no, they don't, although of course a number do. Do you feel that the guidelines they affect the ability to communicate with clients? Most people are saying actually it doesn't make too much difference in the communication. And then on the final question of what people would like to see improve, the answer, as is the answer to so many things these days, is the availability of better technology to help firms comply with these things. So that's the mood of the audience. What's your sort of reaction to that?
Well, I agree that the guidelines are they're more and more complex, and I think that we're seeing a variety of topics in these guidelines, and it's not just, so we're not even seeing that there's one guideline per client. Some clients have multiple sets of guidelines dependent upon the type of work. So we're seeing a very different need for transactional work versus litigation work. And yes, they are too long. They're often too long. And to expect that an attorney can read through the guidelines and also distribute those to all working timekeepers, especially as new timekeepers join the cases, it's very difficult to assume that can happen, and it's taking away from billable hours. So I do see that that's an issue. Now, with regards to whether the guidelines are improving communications, I actually think, I think this is a blended answer. I think in some instances they are improving communications, and I see this more on the administrative side, because I think this gives our administrative team an avenue to collaborate with the client and their respective peers, so that we can help get the bills through correctly. But that depends on, that depends on a lot of things. I mean, we have to ensure that the attorneys will allow us to engage in that conversation. Sometimes they're not, they're hesitant to let us reach out, but this is actually an avenue that we should be taking from the administrative side, because we can often resolve the issues with getting bills pushed through, or what's holding up a bill from going through because of compliance reasons.
Fantastic. I ought to probably draw in Christine at this point. You've given us, Anne-Marie, a fantastic grounding in the real world challenges of compliance with outside counsel guidelines. But Christine, what would you add to what you've heard said there about the shape of this challenge for firms?
I think Anne-Marie touched base on almost every challenge. It was really interesting, though, to see the responses, especially the one that mentioned that the firms are not staffed adequately for the OCG, because I can tell you that this is an increasing problem within the US, and that is only going to feed over outside the US over the next couple of years. If there's not a lot of challenges maybe today, it will increase with every month going by, because we have to remember that these compliance rules that are made for firms, it's so that your corporate clients can minimize the legal spend, right? This is the ultimate goal, for them to be able to give you the rules as law firms. And when you don't comply, they can say you didn't comply, like a vague description, and say, we're not going to give you the €1,000 or the £1,000. We're only going to give you 500. So I think that looking at these answers, I wasn't really surprised, because we know that it's an increasing problem, and it's only going to stay with us, unfortunately, because at the end of the day, the corporate client is trying to minimize that legal spend. And so firms just have to get better. And obviously, I think the answer about technology needing to be the forefront of helping firms is exactly what we need. We need to make sure that we're not adding another body to help the solution, but really utilizing the technology that firms have today at their fingertips, and best using those solutions to make their process more efficient and help them with that, to minimize those issues that they may have.
We're going to come on to talk about technology, I think, a little bit later in the webinar. But actually, one point that you picked up on there was firms thinking we need more people, more resource within the business to deal with that. Is that more of the same kind of people you'd already find in a finance or billing function, or do you think there are specialist skills that firms might need to bring in to help them with this challenge?
So you have to be careful when it comes to outside counsel guidelines. In many years ago, it was as easy as finding maybe someone within the finance department to read through the guidelines and making the decision on whether or not someone else needed to be involved. But today we're finding that a lot of law firms are having lawyers, attorneys reading through these guidelines because some of the compliance rules that are there are very specific to a client, very specific relating to the work that's being performed, where someone within finance would not be able to identify and then forward that on to those timekeepers that are going to be doing the work. So we're finding that years before, it was very easy to read through, but as time has gone by, it's become more difficult. And now you're seeing different roles really reading through. And I think, Anne-Marie, like I would recommend, I think you all have someone of counsel, right? Like a general counsel that reads through these versus just someone from finance on a billing perspective, which is really what should be happening. It really shouldn't be finance because the corporate client is expecting the contact at the firm being that billing attorney or that fee earner that's responsible for the work. They should be reading through these guidelines. They should be understanding for the work that's being performed, how they should be billing it.
And we'll come back to that as well, I think, as we're going to talk a little bit later about who the broader group of stakeholders are in this process. And you've name checked a few of them there, so that I think sets us up for that when we come to it. I'd like to bring in Paul at this point because Paul, your role and your skills and your thinking goes much wider than this particular challenge. But listening to this and getting to know this topic and thinking about data flows and the organization of information within the organizations, how does this problem strike you?
Yeah, I think we're going to have to get better at solving this before it reaches us in terms of hitting the revenues. So as I understand it from an internal perspective to Pinson Masons, it's very much a US problem at the moment. But of course, as soon as everyone catches on that you can save significant proportions of legal spend by challenging the nuances of words and some of the terms that have been slipped in quietly, it's going to be a developing field. So I think we would be looking at, we're already looking at a billing transformation project internally. But this I think is something to follow that in terms of we need to basically form a sort of digital twin of the terms with the client. And then everyone needs to understand and have a very transparent view of that. And when we then go to charge time against it, it's stopped at that time rather than let through the gap so that we can get ahead of this. And then of course you can also utilize machine learning, which can go through and see what's had problems before and then learn very quickly how to avoid those words and those phrases and those things that are put into the billing. I understand we mostly check this manually at the moment, but I think as we try to digitize a lot of this sort of stuff, and we're going to have to get automated on that, and that's where the machine learning will come in.
Fantastic. And let's I think we've, with that roundup of contributions, given ourselves a good sort of sense of the state of the current challenge. But maybe Angela, if I could just ask you, do you see a sort of an arc in the way this is developing? So how, I guess a simpler way of putting it is kind of how did we get to here, and where are we going to go from here in terms of the dynamic between law firms on the one hand and corporate counsel, whether in the US or the UK or elsewhere, who are imposing these requirements?
Right. So, the goal of the law firm is to maximize revenue. And of course, the goal of the corporate client is to maximize revenue with reducing legal spend. And, one of the poll questions about being so complex that a lot of times, the corporate client is making their outside counsel guidelines, upwards of almost 200 pages. And, over the years, as Christine mentioned, a lot of times attorneys and timekeepers and billing timekeepers believe that it is billing's responsibility to take over those outside counsel guidelines and understand what can and can't be billed. And I just think with the evolution of technology, these are only going to become more enforced. You know, a lot of clients are now going to e-billing rather than regular paper invoices. So we've seen that evolve, and the enforcement, it's not always a reviewer that is looking at your invoices. It is a machine, as Paul said, you know, with machine learning, and, you know, taking that and trying to help your timekeepers write better narratives with the who, what, when, why, where, who approved, to make it not so vague.
Okay. I wonder if is there anyone on the panel who can comment on the point Paul raised, which is whether there's a difference in the sort of state of evolution as between different territories, or whether the US are ahead in its practice, whether we see it also in the UK, whether continental Europe or other jurisdictions are more or less active in this. I mean, Angela or Christine, perhaps, I don't know if you see those different geographical trends.
Well, for e-billing, we saw the trends start in the US and within insurance work. So that's where it all began many, many years ago. I want to say over 20 years ago, actually. But now we've seen, we saw that insurance defense or insurance companies really found that the legal spend was being minimized because of these compliance rules. And so then we automatically started seeing large corporations, you know, the Coca-Cola, the Google. So all these major corporations started also going into that gear of making sure that the compliance was there for their firms. And then we also saw that e-billing, especially because this is where we predominantly see those compliance rules, we saw that it was very common here within the US. But then over the last 6 or 7 years, working outside the US, I've seen a major growth in e-billing where these compliance rules are slowly creeping up because, again, the corporate clients now are seeing that their legal spend is minimized. I think, Jan, for what we're looking outside the US, I think what has been saving everyone is that there's a bit of government compliance as well with your e-billing there. And so I think that has held just a little bit of it really reaching there. But I agree with Paul where if this is not tackled sooner than later, it's going to be too late. I've found that with e-billing outside the US, and I feel the same with the compliance.
And I suppose, sorry, do go on, Angela.
And I've also seen that these SLAs and outside counsel guidelines have not only spilled over to law firms, but now accounting firms are receiving from their clients with outside counsel guidelines, and, you know, the banking industry as well. So it is definitely growing beyond law firms to more, you know, other professionals.
And as the boundaries break down between different types of professional services firms, we may see even more of that.
Exactly.
Okay. The thing I was going to move on to was a question then about the stakeholders in the process. So all the beginning of the journey, I suppose, is outside counsel composing their guidelines, then sort of feeding them through to firms and firms absorbing them and sharing them and teaching their people about them. But there's a kind of pithier question which has been posed by one of our audience members today, which really focuses on a part of that stakeholder question. It goes as follows: how have you gotten your lawyers to become invested in or care about the OCGs and realize that they're not just for the billing or other administrative departments to adhere to? Let's see what Anne-Marie says about that, either with reference to work within Holland and Knight or more generally.
Well, I think with regards to Holland and Knight, I think our attorneys, you know, we just, since I started the firm, we've just really started focusing on the billing component of these. And trying to come up with, and I'm calling it a program because it is a program that we're trying to carve out. But I think that, you know, we have various groups dependent upon what's contained within the guidelines these are vetted through the appropriate channels. So if there are legalities, security, information governance, those are all going to the appropriate stakeholders to review and sign off on, and they flow through our business intake department to the appropriate channels. And I think to the extent we actually do a really good job of bringing attorneys into the engagement so that they understand what they can and cannot comply to. And then I call those kind of the deal breakers, because those are the red flag items that say whether we can even take on these engagements. And I know that we do scrutinize the guidelines and go back and actually suggest changes. And you know, I think this may be getting a bit off topic, but I think this is a good point to raise, because you do have the ability to challenge some of the guideline items. And you know, coming from a prior firm that would not challenge anything, we were left in a situation where we were at risk at times. But you know, even before you get to the billing stage, you do have the ability to negotiate those, and I've seen them successfully negotiated.
So thinking about, you know, the kind of very best practice you could establish within a firm, from the kind of the client relationship partner through to the timekeeper supervising the matter, through to the billing team, and more wider than that, what's best practice for each of those people in concerning themselves with OCG compliance? Take the relationship partner first.
So I think the relationship partner, you know, it's interesting. I think they spend a lot of time working with their clients, engaging with a potential client. They bring them on board. They establish this relationship that starts off on a great foot. And I think they think once they're in the door, it's done. And, you know, and then all of a sudden they find out, oh, we have got, it may not have even realized there were outside counsel guidelines, but they think that that's ancillary to the relationship, where it's really a large driver of the relationship. And I tell them, you know, I tell them often, you know, you don't want to bring them in. You don't want this to be the point where we fail in the relationship. And clients are tracking to these guidelines. So it's important that we not only bring them in, set the right foot, but also we continue and we teach our attorneys that, you know, what is contained in those guidelines that's relevant to them, and how is it going to help them continue with driving the relationship and ensuring that it's a successful relationship.
And I think you're sort of touching on the answer to another question which has just come into the chat, which is about whether you feel you've got to the point where the timekeepers themselves, the individual lawyers, feel responsible for making sure that any mistakes are corrected, or whether they perhaps still feel that's something to be done downstream by somebody else?
It's a pretty loaded question. So I think that some attorneys feel like it should be done downstream, that they don't necessarily own a piece of that, but we are really trying to change that view. And you know, this is, so what we've done, let me share what we've done at Holland & Knight, because I think it's helpful to understand what we thought was beneficial to us, that backs into this question. But, you know, to me, the compliance starts at the engagement, and it ends at the conclusion of the engagement, kind of towards the pre-bill billing and the end of the engagement. Those are your two pressure points where you can really impact the success of the client based on the guidelines. And the relationship. So we implemented a role. You know, when I came into the firm, we recognized, I think we looked at where our largest loss was and how we best could get the best return on our investment immediately. And we decided that was to implement a role dedicated to not necessarily the onset of the guidelines, but at the end stage, the review, working backwards with the attorneys, identifying those clients, those attorneys that habitually we experience a great loss in revenue and realization, and taking those so that we can work with them directly. And we dub it as the catch and release program. You know, we're not looking to fix time entries, although we do, that's how it starts, but the point is we want to go back upstream and have the attorneys enter their time in accordance with these guidelines, and to understand that this is on them. We can't just fix what they're doing. They have to take ownership in this as part of the engagement.
And we'll come back in a short time to talk about the kind of technological solutions that might be or becoming available to help the timekeeper at their desk with that task. But just sort of step to the side a little bit, I wanted to get a sense from people of how big a problem we think this is in practice. I mean, Anne-Marie, as you're on there, I don't know whether you've got any sort of either data or just general sense you can share of how big an issue economically this kind of compliance management is or could become for your firm or firms like yours.
Well, I know on average we're seeing 12 to 15% reductions on invoices, and that's, I think, pretty standard. You know, and it's part of, I think it's pretty standard as far as what clients are looking to control with their legal spend and minimize. So we're seeing that, and you know, and until you stop that, it's going to continue. And as more clients, and Christine touched on that, and it was in the poll, that people don't know where the right role is to handle this. I think there's confusion about how to just start this program, and where do you start, and who are the right people to start. Because I think up until now, we've had a lot of variety of people trying to fill in roles as they've had exposure to guidelines, but they're getting to where we really need to dedicate the resources that have the time to go back, because this will just continue.
And that's quite a sort of striking number, isn't it? Because if the fee for a job is reduced by 10 or 12%, the profit on the job is potentially reduced by something like 3 times that, depending on the margin that there might have been. So that's very significant. I wonder if Christine or Angela might be aware of broader research or understanding that there is across the industry to see whether the gap is sort of that profound more widely.
So with that, as you had mentioned, Ian, a lot of times, you know, they have negotiated rate. You might have your timekeeper, their standard rate might be $475, but with the client, it's reduced down to $250 or euros or pounds. And then with that, the client is looking to save even more. And depending on the compliance or non-compliance of their outside counsel guidelines, invoices might even be reduced up to, you know, upwards of 25% because of vague narratives or items requiring prior approval that they didn't include in the narrative, you know, who they received approval from. So it's a great deal of reductions that they're seeing, and based on if your timekeeper is compliant or not when billing.
And I mean, are you aware of any sort of research that there might have been, whether it's sort of survey data or just kind of financial research that's been done to help gauge this more accurately, or is it still a little bit invisible as to the true implications?
It's still a little bit of invisible. I know we've performed the outside counsel guideline, the OCG survey, and that is one of the larger issues is the clients reducing rates that are already reduced based on non-compliance.
Very, very significant. Well, let's move that into talking a bit more about technology as a solution or a way of managing these issues. I'm going to actually talk first to Paul and to Chad about this as I guess two of the sort of pure technologists on the panel, and you've heard the various stages of the problem being described to you. So to deal with this, the firm's got to ingest multiple different sets of guidelines for multiple different clients. It's got to somehow help timekeepers at the point of recording time to understand what their requirements are and get the narrative right. It's got to process all of that information and present it in the right way, and it's got to have sort of checks and balances all the way through that system to make sure that we don't suffer this loss of time in the way that's just been described by Anne-Marie and Angela. So I know this isn't the way that systems architecture kind of should be done in a Zoom call, Paul, but high level, what would you see as the way a technologist would think about approaching this problem?
Yes, certainly. So I would see the terms being digitally available through a client portal, and the nuances and the sort of clauses within the terms being categorized and agreed upfront before and also analyzed upfront before it's signed off in sort of paper manuscript, so that the billing system would be made aware of what's in the clauses and would then control what's permissible and be aware of what's permissible with sort of use of a rules engine on the sort of timekeeping side of it, so that you're not faced with these difficult decisions and this sort of burgeoning industry of investment into challenging the bill, because you can just feel all those little business cases flying around saying, we can set up a team and we'll save 5, 10, 15% of our legal costs, which on the surface looks fantastic. And he's certainly going to attract investment if it's not there already. So we need to keep it as a sort of as an afterthought, really. And to do that, I think we should get ahead of the game and start to introduce the sort of portal context of representing the terms in a portal, so that all the clauses are laid out, agreed by both parties, and then represented in the timekeeping and the billing system, so that there's no room for manoeuvre, and everything is agreed up front and completely transparently, and you can't even bill for it from the timekeeping perspective. To keep the lid on this, really, because if we're faced with, I think I'm hearing anecdotally that the US tend to slightly overcharge on legal matters, probably to cover this, and then I think it feels like a slippery slope, doesn't it? It feels like it's compensating for the billing cycles, and there's a compensation already set in there. But it'd be great if we kept clear of that, really, and got ahead of this in terms of digitizing the whole experience and making it completely transparent. And also, if there are any changes to the terms, then that is properly authorized by people on both sides of the contract who can agree to those changes and then publish them, and it's all transparent.
So before we come to colleagues from Adarant who obviously have been taking on and solving some of these problems in practice, Chad, you've heard Paul sketch out a sort of technologist's approach to the problems we've been discussing. Is there anything you'd add about the way this could be thought about?
Yeah, as Paul said, technology can assist with, managing compliance at kind of every phase of this. And what we've been working on internally is kind of, creating this central repository. The poll alluded to the fact that these OCGs are becoming more complex. I've always taken the view that the legal contracts and are complex by nature, very nuanced. So we're focusing on capabilities to be able to extract and feature, extract features and be able to measure things in text. That's the beauty of the technology innovations we have at the moment. So by centralizing this, we're just looking to enable ourselves to be able to kind of plug into any point in this process down the road. So it's all about technology enable at the moment, knowing this is coming to more into the UK, and really being ready for it from a technology point of view.
Yeah, no, that makes perfect sense. Actually, there's a kind of sidebar question which has come into the chat. It's addressed again at this sort of kind of theoretical technologist point of view, building on what Paul was saying earlier about the UK perhaps being a little way behind maybe the US on how urgent a sort of problem this is. But the question I think is asking if, when you guys are asked to focus your attention on regulatory or compliance type issues that the firm might have, is there anything that's sort of front and center or sitting well above this in terms of your agenda? I appreciate it's a slight kind of sidebar, but any reaction to that, Chad or reg tech or compliance type questions?
Yeah, I can give you a bit of what what I've thought of. I think there's probably a conference going right now. It might be gardening centres or supermarkets, or it might be, a retail chain, and they're doing a discussion about how they can cut 15% off their legal costs. And this is how you do it. You turn a 15-page set of quite clear, concise guidelines into 200 pages, and you can invest into a team that can cut your legal expenses down, and that does give me concern, because it attracts complexity, and complexity is going to pay it's going to pay off to do this thing.
But let's take your ideas, which you outlined just a few minutes ago, of the portal, which is, I suppose, is kind of shared data resource, which manages the OCGs in a structured way. And let's bring in Christine and Angela to talk about the way in which the technology provider industry has been seeking to address these particular problems of outside counsel guideline compliance, and what the current state of best practice is in terms of firms' use of technologies. Christine, do you want to answer first, or invite Angela to do so?
I can take a shot at it first.
Do.
And then Angela will add in. I think what Paul was talking about is a great idea, right? We want to be able to show everyone that's involved about the compliance, the rules, so that they understand how the time entry needs to be done. Mm-hmm. Within a financial system, and I can take just Adirond as an example, you have the ability to set up billing rules. Within OCG Live, you have the ability to set up time entry that will then flow into the billing. You also have Bill Blast that will help, manage the e-billing piece of it, where if at stage 1 and stage 2, you didn't comply, at stage 3, which is the final stage, you'll still be in compliance. So all those stages, the technology is there. It's just a matter of using it, right? It's implementing that, being very strict with that implementation. But then we have to do what Anne-Marie was saying, which was a great idea. We need to be proactive after the relationship is done, or after the matters have been complete, the work has been performed. There has to be a review. So that way I can go back as someone from finance, I can go back to that relationship, attorney and say, this is what happened. This is what you agreed on at the beginning of the work that was being performed. This is what happened at the end. And if you get more work from this client, this is what we need to change. And that is going to better the relationship over time with that corporate client, but it's also going to help dictate on the time entry, the timekeepers, because one of the things that we need to remember is I can be timekeeper A, doing work for 20 different corporate clients across my firm. And it's very hard to manage the rules for this person versus that corporate person, because they're all so different and complex. So you want to be able to have a rule that when I'm entering time, it says, stop, Christine, you're doing this wrong. You need to reword, or this is too vague. But then we also want finance to have something that is identifying you're about to e-bill this invoice and it has a compliance error on it as well. So really all stages, you have the ability to manage it with technology that's out there today, actually.
So those two stages that you've identified for us, one is the point at which the timekeeper is entering her or his time, and I guess that's a mixture of manual time entry and sometimes passive time or background time capture, and the other is the point at which the bill is being drawn up, either by those individuals or their executive assistant or the billing team, and you've described a piece of technology which can help at each point. But just so people can understand in the sort of the real world, whose pain point do those products tend to address, and what's the sort of feedback where you've got kind of live installations of those?
For pain, I really wouldn't say so much as pain points within, because it's mostly finance that's going to be doing the setup. I think timekeepers, like Anne Marie was mentioning, you know, you have these relationship partners, they went to study law. They just want to practice law. They don't want to deal with compliance. So for them, for the timekeeper, the pain point is they're receiving these warnings that they've done something incorrect in their time entry, and they feel like, oh, now I have to reword this or add more, you know, information on the time entry. So I think if we're looking at the relationship partner, the pain point for them is they have to, you know, abide by the rules with time entry. When we're looking at finance, the pain point is the setup, and then having that review, going back and having people listen to what we're asking them to do for that proactive approach versus the reactive approach, which is why I'm in such an agreement with Paul. Fix it now before it becomes a problem, because when it becomes a problem, it's harder to fix.
And there's a follow-up question which has come into the chat, which actually I'll draw Angela in on, if I may, which is really it's a classic user adoption question. So with something like OCG Live or another tool which helps people at the point of time capture, the question effectively is, how do you get your lawyers to buy into and use that technology? But I suppose a related question is how far they actually need to voluntarily buy in, or whether it's just a tool that assists them, whether they seek the assistance or not. Angela, what do you think?
So the best way to get buy-in into technology is show them the bottom line. Timekeepers understand monetary value and loss of business. And with that, you know, as Christine said, they went to school to be attorneys, but however, they did go to school to be attorneys, so they need to be paid. And if they're not being compliant, not only is their revenue realization decreased, but also if the problem continues and they continue, you know, with being non-compliant, there's also the loss of business, because, you know, in the US, they are, you know, these clients are now starting to grade law firms on how well outside counsel guidelines are being complied with. So the short answer is to, you know, show them the bottom line. You know, it's with money. If they're doing all the work but not getting paid, that is the biggest issue.
And from my experience, I think the attorneys, you know, that when they see the bottom line and understand the impact of these reductions, they're very frustrated. They know what's happening, but when you show them the final numbers, they want to make this better. I think they just don't necessarily know how until we can provide the opportunity or the products to help them. And, you know, at time entry, that is the point we want to capture this. That's our greatest return right there, and it limits most of the issues. There will still be some items that come through, what I referred to earlier with the variable issues and reductions with the descriptions. We can you know, point that out to an attorney, but there also needs to be some form of additive AI that you can, you know, the firms can adjust their technology to capture things as they're learning more about the individual client and the reviewers, or the mechanisms that the technology on the other side is reviewing, so that we can establish new rules that
right.
adapt.
We'll come back and do a little bit of AI Imagineering as we move towards the sort of last part of the session in a few minutes. But one thing that discussion about the you know, the individual timekeeper and the folks in the billing teams and the kind of experiences they're having and the tools they've got available made me think about is, of course, the remote working experience that everybody's had over the last 12 months. And I just wondered if anyone had a perspective on whether the remote working, the enforced remote working of the last 12 months and the potential hybrid working model of the next few years, what are the implications of that for our topic today? Christine, do you have a view on that?
I think that for the remote work that we've been seeing over the last 12 months really didn't affect too much for timekeepers, because I think we already had folks that were doing a lot of time entry remotely anyway, right? We had a lot of folks that were traveling and they were entering time on a plane. I think the bigger piece is going to be bringing all the teams together continuously, still remotely, by providing them with reports versus someone, just walking down the hallway to an office to let, Paul know how he did on the billing perspective. I think that we're going to see a lot more integration with teams. And I think it's going to be a lot of maybe analytic data that's going to be provided. That's going to be a big key. I think that's really important for everyone to, again, that proactive approach, that visibility that you want to be able to provide to those relationship partners, but as well to the timekeepers, so that they really have their, the understanding of what they've been doing. But I don't see that that much of a major change with regards to the timekeepers. I think for finance, if we continue with the remote work versus the in-office, that may change a little bit. But again, I just see that, if there were any challenges, we probably saw them first 6 months. I think everyone by now has really has had a great opportunity to get a great plan in place for all their teams. And so I don't think we'll struggle with that going forward.
Let me come back to you in a minute or so on one point, which is just around the kind of management information and dashboarding that perhaps will start to become more visible. But I just wanted to check in, at least with Anne-Marie and others, if they have a view on whether the remote working has had an impact that Christine hasn't already described in her answer.
No, it did not have an impact on us. And in some ways it actually, we still move forward with the program we've been developing. And I think what was hindered was related to just the pandemic in general and shifting gears for other focus areas, but it wasn't the ability to move forward. We still were looking at technology and what was out there and ramping this up, so that this year we're going to move forward with more of the technology focus.
And Paul and Chad, you've, I'm sure, had a great deal to do with supporting or delivering the remote working platforms for Pinsent Masons, but I guess this isn't an issue that's sort of been right up there in terms of visibility just in that remote working adjustment.
We transitioned fairly easily, but under the surface we were running around, meeting ourselves, coming back. It was a very intense time back when it switched over to 100% work from home. We doubled the worldwide bandwidth and did some of the fairly significant changes. But we seem to have succeeded that, and there weren't any significant problems. Just back on there's a question come through about the technologist. Proof to the lawyer to demonstrate importance of compliance. And it harks back to the point that the lady was talking about in terms of how do you get lawyers to be interested in this tech. And in my mind, I had, when you're entering a piece of timekeeping and entering a description and editing a description that would be non-compliant, I would certainly look to demonstrate the clause that it was in contravention to on past history, and also highlight perhaps a different set of wording that could be done. And those sorts of technologies are available today. And certainly that's something that we'll be looking at as part of this. So the lawyer would instantly, just in answer to the question, the lawyer would know there and then that probably the timekeeping entries that they're doing are non-compliant, and just fix it as they put it in there.
Real time.
Yeah, I guess, I mean, Chad.
Sorry. No, I was just saying, yeah, that I agree with Paul. More real-time feedback. We have that around us in our everyday lives with lots of things we do. Online shopping and lots of things. And these technologies are available, and it's something that we are looking at utilizing.
And it happens. We already get guided now. Like the sort of Google "Did you mean" thing, yeah. Or the little tip here and there, and it's done in a It doesn't do it in a sort of computer says no sort of way. It does it in a kind of nudge way. So it's going to say, there might be a problem with this word or this phrase, because here it's been used before and it was seen as non-compliant. Would you like to use this word? And he said it's about the way these things are phrased and handled. So it's not sort of so in your face and it's sort of fighting you, but it suggests and nudges, perhaps a slightly different word or a less convoluted way of describing a piece of billing.
I'll just make a quick observation before I go back to Christine, which is there are definitely different types of lawyers within the firm, and I guess different structurally on the one hand and emotionally on the other. So the perspective that the relationship partner might have on OCG compliance will potentially be different from the mid-level associate who's kind of looking to get the job done and return some good figures. But the other dimension, of course, being there are probably some lawyers you actually will take very seriously, delivering the highly compliant service in the way that the client wants it, and others who have slightly more of a tendency to think of themselves as people there to deliver their craft and let others worry about the administrative aspects of the relationship. But that's just my little take on it. Christine, I said I'd come back to you just on this question about management information or dashboarding, so that firms and maybe individual timekeepers or individual relationship partners can start to see more directly, more graphically, the positive and negative effects of good or bad compliance.
I could tell you that's almost the number one question that I guess get asked all the time is, how can I report on where we're missing compliance, what is being reduced at time of billing, and how much? And firms don't want to see this not only by timekeeper, but by total numbers, by month, by quarter, by year. So that way that relationship attorney has the ability on the next conversation with that corporate client to discuss how they're doing. So dashboards, analytics based on time entry is crucial. Obviously, I work with the team at Bill Blast, and we have great, dashboards that help specifically only on deductions, giving the firms the ability to run reports at a line item level, how timekeepers are doing. And that's key. Just like what Anne-Marie was talking about with the review, it's so important to have the ability to go run a report on Paul's time entry for a client for a period of time and be able to provide that back. Because just like what Angela was saying, it's the bottom dollar. I need to let Paul know he has cost the firm potentially 100,000 pounds, for example, right? This is how Paul would need to get better with time entering that, with this client. Because again, corporate clients are grading, they're comparing based on the work that's being performed. So you have to be very careful that the analytics or being able to provide statistics to timekeepers as well as relationship partners is going to be a key part of the process to be successful and for you to be able to get better and to make that relationship also a positive relationship with your corporate client.
And can I just add to that, we are using the analytics features within Bill Blast when we submit our bills electronically. So we're able, that's actually how we determine the priority levels of clients and timekeepers that we want to focus on. And it's extremely helpful to us because it's live data, it's real time, so we can shift course as we need to. And there's a component of this that we haven't touched on, but for those timekeepers that are not, where the compliance is not getting better and we're not seeing the results, it helps to have strong leadership in place that's willing to go to deal with this. And unfortunately, we do have that, and we have very supportive leaders who are working directly with us.
And I think it's related because one of the things we chatted about when we were having our preliminary discussion was the kind of experience, and this will often fall on your team or your kind of equivalent colleagues in other firms, is once a bill's been submitted, if there are areas where it's not compliant, you can have this process. I think we started talking about it as ping pong, of just kind of going backwards and forwards, trying to resolve increasingly small queries about things. But just maybe talk a little bit about your experience of that and say where you think we are now in terms of the technology that's available to smooth that path?
So yes, we are seeing, we do call it the ping pong match. We have a lot of phrases for our compliance work. So right now, I mentioned that we are still early in the stages of implementing technology. We've looked at several products. We're trying to figure out what will work best for us. And part of the reason we're further along than we wanted to be was, I mentioned we kind of sidestepped during the pandemic for other reasons. But we have a role dedicated to working with the attorney and actually creating, not only doing some pre-audit for certain clients where we see large reductions, but also creating appeals. And I mentioned that we have a very supportive leadership. We actually had a leader who had the innovative idea to utilize some of the paralegals who had low hours last year to help us craft the appeals and do this pre-audit, and also create kind of these condensed helpful guidelines to send out to all the attorneys so they don't have to go through a 200-page document if they're going to pick up work. So what happens, we find, is that and I've seen this role successfully work before, but we go back, we pre-audit the time, we make revisions as needed, we submit it to the client. They will still look for something, like we've talked about. This is still a cost-saving effort on their behalf, so they are going to look for something, and this is where the variable reductions come in, because the person dedicated to this role will get back a question. It's not uncommon to have clients who will kick it back into our queue for further review. We have to review it, spend the time, and if you don't have the proper roles, the proper technology in place, it becomes this match of who's going to give first. We can respond, push it back to the client side, they'll review again, and this review can go back and forth for an extensive amount of time until finally someone gives and says, okay, fine, pay the bill, I'll take a 10% reduction because I just want to get paid. So, and what's interesting is that we see this as we get better with certain clients and certain adjusters or reviewers on the other side. As we get better, they look for different things. They change their course. And it's interesting that our reviewers on our side, eventually start forming relationships with them, and sometimes even share things that they're each looking for. And it's just an interesting world with compliance, because it's very dimensional and lots of obstacles to overcome.
Sure. Well, that paints a very vivid picture. I'm just going to pause there, because we've had some great questions coming through in the chat, and I've tried to pick up on a good number of them in the course of the discussion. We'd certainly welcome a few more, because I'm going to cover a couple of other things, but there is then some time at the end just to kind of pick up these free-form questions that people have. We probably also ought to get to the second poll around about now. So I'll just ask my colleagues from NetLaw Media when they're ready to, here it is. They're always ready at NetLaw Media to fire up that second set of questions. I want to spend a little bit of time talking about the future, even the sort of midterm future, and the possibilities of technology in this area, what the sort of state of the art might be in 3, 4, 5 years time. And then I'm probably going to go back round the panel just to hear some concluding thoughts from each of you, and in particular anything you would like to bring out attaching to this topic that hasn't already come up in our discussion. But let's talk about the technology. We've had a good account from Adarant a few minutes ago on the current sort of state of the art and systems that are already available. We described the problems, challenges of adoption, and the kind of techniques that can be used to help manage that. But Angela, is there anything you can share about thinking on how technology might evolve, broader kind of practice management technology, maybe not just narrower billing management technology, that people ought to have in their minds as they plan the midterm future?
So right now, the technology is out there, with Adirant, and we have our, with our iTimekeep and OCG Live product, that we can manage the point of time entry and control that. And as we're working on an initiative to bring all products together and have for lack of a better word, core compliance, to where systems can work back and forth with each other. As Christine mentioned, the analytics piece from Bill Blast, that can then feed back to OCG Live and, possibly give suggestions of rules that could be created before it even gets to the invoice stage and e-billed. So that is, in the process of evolving and being able to leverage your technology that you have and what is available out there.
Christine, what would you add to that?
I think she made a great point. I think that, while firms may have, a financial system, but then all the other products that are helping assist with core compliance, it'd be nice for, different systems to kind of talk to one another so that they can get smarter, right, over time and be more helpful than, having just different sections or times during the process, right? We want to be able to know that even at time of e-billing, whatever happens within e-billing kind of reports back to the billing, to the timekeeper, but all within the technology. So I'm hopeful that within the next couple of years, we'll see that integration with products. That way, everyone's learning versus having to go to different products to learn different pieces of the process.
Paul, I think that's a very good point about greater integration, isn't it, between different parts of the firm's broader software architecture or environment. I wouldn't expect you to disagree with that, but what would you add to that in terms of future state thinking? And then at a good moment, bring Chad in, because I know he'll have further comments on the art of the possible in machine learning.
Yes, certainly. This will be a big area where we can exploit machine learning. So, Christine, on your point there, I agree. It would be that point of entry sort of catchment that would highlight the potential change or a machine learnt alternative to the wording used there based on previous instances of that phrase or word being flagged up for challenge. So, Chad, is there anything you'd like to add from a machine learning perspective?
I think not specifically from machine learning. Because this kind of is sort of encompasses a lot of what we're doing at the moment. But also going back to Christine and Anne-Marie both talked about dashboarding and analytics, and I see this transition from people going to look at a dashboard on a regular occasion to almost real-time notifications, alerts, people being told of information rather than having to go and seek it, and that paradigm shift certainly needs to be happening. I think that's all I can think of though off the.
Very good, and then the possibilities I'm sure are endless. People's attention will have been I guess directed to the results of that second poll. So maybe we'll have a quick look at those together. And again, do encourage people to put in any further questions they may want to have asked. But looking at these results, we have a very good number of folks on the call today. So I think this can be taken as being an interesting and probably statistically significant result, but which of the following do you receive from your clients? And very great majority of people on the call identifying the receipt of SLAs or outside counsel guidelines. So hopefully for people, it's been a timely and relevant discussion. More mixed views on question 2 as to whether the firm has a process to review, analyze, and document the requirements as they come in. And I think the picture you get there is, firms are aware of this. They're making, good efforts to manage the receipt and compliance with these requirements, but it is, I suppose, somewhat patchy, perhaps because of the absence of some of these rules-based comprehensive systems that we, I suppose, sketched out on the call. Who within the firm is responsible for reviewing and analysing the guidelines? And the most popular answer there is the billing department. Partners and finance directors getting a bit of a look in, as well as the legal operations team. But that's just one thing that comes out of the call is it's very much a shared problem, which can only be answered by a shared effort within the firm and with the broader stakeholder community. And then the last question there, describe the process of sharing the contents of the SLA's guidelines with timekeepers, and the most popular answer, we distribute summaries to lawyers working for that client with guidelines. And that's perhaps the answer you'd expect, but I hope people will feel some of the approaches which have been outlined, current approaches which have been outlined, and future possibilities which have been hinted at are very worth exploring. So I think very useful to have that sort of second set of poll results as a sense check on everything that we've been discussing. And what I did want to do is just allow a little bit of kind of free opportunity for the panel to pick up on issues that they think are pertinent to this topic, and just to sort of draw some of those out in the last 10 minutes or so of the discussion. So maybe Angela, perhaps I can come to you first. Is there anything that we haven't covered, or anything you'd like to say something more about in this area?
No, I think Anne-Marie covered a lot of it. It does come with educating and teaching your timekeepers how to write better, more compliant narratives. And that does come with giving them the summary, summarize what is billable, non-billable, what's, requires prior approval. So it does come to the point of you don't know if you're not told. So I think educating and providing support to your timekeepers and giving them, if their narratives are containing words that the client's AI is going to pick up, offer them alternative words and help them with those narratives, help them write better narratives so they're not vague, by providing the who, what, when, why, where. Be as detailed as possible. And then I think just the more granular the time entry is, the better it is for the client.
Thank you. Chad, let me come to you, because there's a specific question atting you in the chat, which you haven't seen. It runs as follows. If real-time...
funny enough, I was just typing a response to that, so I'll go ahead. Yeah, with the real-time notifications, and yeah, you agree, an overload of information, but these need to be, managed carefully, in that notifications come only for, outside of particular concern. There is a problem with something, it notifies you. There's lots of ways of managing this, and it's probably almost a separate session on its own, but I'll try and type up a more comprehensive answer to that one.
Very, very good. Paul, again, it's been a very sort of interesting discussion, and we had a couple of calls to sort of explore it beforehand. Is there any of your sort of thinking or stuff that you've picked up from colleagues within St Masons that you'd like to add at this point?
Yeah, it's been an interesting discussion between my colleagues, because everyone agrees this is going to be a developing area. So, and as I previously mentioned, if we don't get on top of it, it's going to attract investment and complexity that we can all do without, and doesn't really add to the cause. I'm also aware that it causes consternation and tension with the client, and this repeated sort of, I think you called it ping pong, is it Anne-Marie called it ping pong, doesn't help anyone really. So I'm eager to to have a look at this in terms of technology. We've already got quite a huge program going on that the finance are running in terms of the billing transformation project. But talking to the people involved in billing, certainly they all think that this needs attention now rather than later, which is a really interesting perspective, because I agree in that it's going to escape if we don't if we're not on top of it.
Fantastic. Anne-Marie, very generous with your sharing at the start of the call and throughout. I know that the delegates for the webinar today, there's a lot of sort of C-suite folks listening in. I mean, what would be do you think the sort of 2 or 3 key takeaways that those in senior management positions within firms who maybe don't see the kind of front line of this challenge week in, week out, what would you want them to be taking away from this call?
Sure. So I think some of the big takeaways are that this is not going away. In fact, this is going to continue, and we're going to continue to have to find the right tools to combat the degradation of our time entries. I do think that it is worth investing in experts in this area. I think that you need dedicated staff to lead this charge. And that was one of the poll questions. You know, sometimes people don't know where to start. And I think that in my experience, seeing billers or e-billers or other administrative members try to dig into this at the level that we need is not sufficient enough. We need dedicated staff to drive this and to look for the technology, and this is their sole focus. And I think one thing we should expect to see, and this is really important, that as we're improving our metrics and we're seeing successes with this, the clients will evolve and they will change. We just had our first set of guidelines come back where we are no longer allowed to submit appeals. So they're taking that piece away from us, which, you know, on a 12% to 15% reduction, we've been able to recover all but less than 1% of it. So that's pushing this back upstream and saying we have to get this right from the beginning, and we need the technology and the people that it takes to do that, because in the long run, this is going to add to the bottom line, and it's very much impacting us.
Powerful takeaways. Christine, your concluding thoughts on the topic.
I think Anne-Marie said it best. I mean, we really need to focus that on the idea that this is not going away. But I do urge C-suite folks or C-level folks to really listen to those that are in charge of the reading, the reviewing, the finance department, because they are really giving back true numbers, true reports on what's really being done within the firm as far as billing. They are the leadership that's going to drive that change within those relationship partners, with those timekeepers. And so it really does help. And like Anne-Marie, she has great leadership at Holland & Knight that really listen to her recommendations, listen to her team, and they drive that change. So you really need to make sure that you also have that as well. So if you don't have a process today, set up a meeting, start talking about it now before it becomes a problem, and make sure that you have a good process in place that you can begin acting on even as early as, you know, tomorrow.
Fantastic. It's a good point, I think, to start to conclude. Firstly, it's to me been a very interesting discussion, greatly enriched by the variety and depth of perspectives that we've had from our panelists, and also for the very many incisive and interesting questions which have come through in the chat. We set out to explore the sort of current state of the art, what is the outside council guidance compliance conundrum. I think we've unpacked that with many good practical examples. We've talked about, I think, a lot of best practice approaches to managing it, not just the technology solutions that are available, powerful as they are, but also the management practices, both locally within firms, whether that's within the client service groups or whether that's within the finance team. And we've then gone on to explore some of the kind of state of the art, the possible which may come through in the next year or two. Peppered, I think, with real illustration, both anecdotally and in terms of some of the data that's been talked about and shared of the real impact that not getting this right can have on people's revenue and increasingly, or perhaps more so, on their margins. So the takeaways which were given at the end there about the real world nature of this problem and the ear of the C-suite that those charged with tackling it would like to have, I think, are pretty powerful messages. To help wash down and lighten those messages, I do hope that everybody received or their adherent cocktail glass and instructions, and depending on where you are in the world, it really can't be long before you can legitimately try that out. In the UK, happily, you have some sunshine this afternoon to be able to do that. So I will start to conclude just by saying thank you to everyone, both my panel colleagues and also everybody who's taken the time to join us this afternoon for being at this legal tech talk hosted by NetLaw Media. As I said, it's been a very interesting discussion and a great pleasure to host it and talk things through with you. I can go on to give details of the next legal tech talk, which is on the 10th of June at 3 p.m. I believe UK time, and it's an exclusive interview hosted by the very well-known legal broadcaster Clive Coleman, talking with no less an expert than Professor Stephen Mason, 1 year on from the release of the publication of Professor Mason's report on legal services regulation. That, I'm sure, insightful discussion will centre around the past year's progress with those report findings. So please, everyone, do put that date for the 10th of June at 3 p.m. In your diary, and NetLaw, I'm sure, will be following up with the comms around there. But for now, thank you very much indeed for joining us. And don't forget, please, to subscribe to NetLaw today and be part of all those important future discussions. So thank you very much, and good afternoon.